Welcome to the Three Questions webcast series. I'm Wayne Baxter, Senior Executive Manager with One Capital Management. At One Capital Management, we develop and implement strategies for our clients that strive to grow, protect, and ultimately distribute their wealth. And we do that by offering investment wealth management services. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions webcast series, please consider liking this video and subscribing to our YouTube channel. My clients are often referred to as cross-border clients. Now, why is that? Well, it's because they're either U.S. or Canadian residents who invest in U.S. and or Canadian dollar-denominated securities like stocks, bonds, or ETFs. The process for advising our clients includes an in-depth discovery and diagnostic analysis of their wealth management goals and objectives. Now, the goal of the Three Questions webcast is to educate and inform you about some of the financial issues that you may encounter, and in doing so, introduce you to experts that may be able to assist you. On this edition of the webcast, we're going to talk about the steps Canadian entrepreneurs should consider when looking to expand their operations into the United States. On this edition of the webcast, we're going to be asking the three questions Canadian entrepreneurs should ask before establishing a business in the United States. Joining me is Adam Treiger. Adam is a partner with Southern California law firm Stowell, Zeilenga, Ruth, VAUGHN Treiger, LLP. Adam is a frequent speaker on employment law, business law, and litigation issues, and also has authored numerous published articles. He's a true expert, and I really appreciate you having on the webcast today. Adam, it's great to see you.
Thank you, Wayne. Pleasure to be here.
Yeah, I really appreciate it. I got to note something right now. I want to point out that the questions that we're addressing are relevant for U.S.-based entrepreneurs as well as they are Canadians. This is not only a Canadian-only episode, although obviously our webcast is often viewed by Canadians, hence the reference to my Canadian cross-border clients. Before we get into the three questions, Adam, why don't you take a couple minutes and provide us with an overview of the types of clients that you typically advise and the services that you provide. Just give us the 35,000-foot overview of the practice.
Sure. Thank you, Wayne. In my practice, I represent businesses almost exclusively, and those businesses are, you could describe them in lots of different ways. I usually say small to mid-size. I generally refer to the size of the business by their employee count rather than by their gross revenue number. So for me, if you a business with 0 employees all the way up to maybe 200 employees is where my clients are, and the vast majority of them have between maybe 20 and 70 employees. So that's basically who my clients are. I am an advocate for entrepreneurs and small to mid-sized companies. I believe that they are the backbone of our economy, that they are a driver of good things in the world, and I view it to be my passion and mission to protect them as best as I can. And that starts with some of the questions we're going to talk about today.
And again, mostly there's a term, I think when I moved here from Canada, a term that I never heard before, and there were a few, was the term closely held business. I remember being in a meeting with someone, and they said, so is it a publicly traded or closely held? And closely held, what? So in your case, we're talking about a closely held businesses, correct, that are basically privately owned as opposed to publicly traded. Is that correct? Or do you also work with publicly traded companies?
Mostly that's correct. I do have a few publicly traded companies for whom I work, but my role for those companies is much more limited than it would be for a privately held or closely held company. Publicly traded companies generally have a great many lawyers and staffers and HR people and in-house counsel. And so when they come to someone like me, it's for usually a discrete, complex issue that I can help with. On the other hand, closely held companies, that is privately owned companies, often use me as their primary source of legal advice and counsel, HR help, corporate help, and certainly I can't do everything. And when I need help, when I can't do something or something outside of my expertise, I am the first person they ask for referrals. So I would say that mostly it's privately held companies.
All right. Now, I mentioned I moved here to the United States. It was about over 10 years I've been here. It's hard to believe. I want to make a note here. Probably some of the best advice I ever received was from Adam, and I was getting my cross-border business up and running, and I can't thank you enough. I remember the quote unquote, the go wide recommendation that you gave me back then, and I'm forever indebted. So, Adam, thank you. And I never forget. I really appreciate
You're
that.
welcome, Wayne. I appreciate that something I said struck a chord with you.
Was a very well, maybe sometimes I'm naive to a thought, but I took it to heart, and thank you. Okay, let's get to our three questions. Canadian entrepreneurs should ask before establishing a business operation in the United States. The first question is this: what kind of legal entity should I establish for my US-based business? Okay, Adam,
Excellent.
take it away.
I will. So before we answer that question, we have to say there's a sub question, which is, do I even need an entity at all?
Fair.
And the answer is no. An entity is not required. A sole individual person can have a business that is known as a sole proprietorship, which is not a legal entity. It's just the person doing business. Generally, that person can register a fictitious business name, also known as a DBA, and they can use that fictitious business name to do business as themselves without a legal entity. Also, if there's more than one person, like 2 or 3 or 10 or 20 people, they can have a general partnership. A general partnership is not a legal entity. It's merely a conglomeration of people doing business together, rowing the oars in the boat in the same direction, trying to make a profit in the business they've chosen. They're not legal entities because there is no legal protection around them. We usually call that a corporate veil. There is no corporate veil around them protecting them from liability. There are often not very many tax benefits one can take when you're not a legal entity. But being a legal entity has its costs and its administrative burdens. And so sometimes people say, well, I'd rather save the costs and the burdens, take on the extra liability, and not have a legal entity. That is not my recommendation, but it certainly is possible. So if you say, no, I'm happy to spend the costs and take on the administrative burden in order to have the legal protection, what kind of entity should I have? Well, there are really only two in modern day that are used in business. One is a corporation and one is a limited liability company known by
LLC,
moniker LLC. Sure, there are other types of entities such as an LLP, like my law firm, and an LP, a limited partnership, but those legal entities are specialized and antiquated in some ways, so I'm not going to talk about them here. As for the corporation, there are two types. There's an S corporation, the letter S, and a C corporation, letter C. S and C refer to subchapters in the tax code, United States tax code, and they delineate types of corporate taxation. A C corp has a corporate level tax, and once money is distributed down to individuals, it has an individual income tax. An S corporation has no corporate level tax. It's known as a pass-through entity, and so it's taxed only at the individual level. There are pros and cons to both of those things, but for most small, closely held businesses, S corporations are the proper choice, and generally it leads to large tax savings. Now, you can only have 100 or fewer shareholders in an S corporation, so you don't find publicly traded corporations as an S corporation. But if you are a Canadian company or entrepreneur and you have 100 or fewer employees, then it's possible to be an S corporation so long as all of the owners of the shares are individuals. You can't have other entities own S corporation shares. So there are limitations to the S corporation too. Another limitation is that a foreign national can't own the S corporation shares. If you are a Canadian person and you are a citizen of Canada and not the United States, you haven't gotten your citizenship yet, then you can't have an S corporation anyway. So there are some limitations. But never fear. If you want to try to get this better tax treatment that an S corp offers, but you're still a Canadian citizen, no problem. You can form an LLC. LLCs are also pass-through taxation entities, and anybody can own their shares. Other legal entities, foreign nationals, including Canadians, and anybody else. So an LLC is often the go-to solution for a Canadian who is coming to open up a business in the United States.
The income though goes through to the owners, though, correct? The owners of the LLC. They all the income generated by the LLC goes through the to the owner.
All of the income generated by the LLC is allocated to the owner for tax purposes. Whether the cash goes to the owner's pocket is
Yeah, I'm talking about the taxable income.
Right. It might be that money is held in reserve, or it's making capital investments or something. And to the extent that that happens, there may be taxation paid on money not in your pocket. But that's true for S corps too, and maybe kind of complicated for this discussion. Also for the LLC versus the corporation, LLCs have far fewer corporate formalities. You don't have to have meetings every quarter. You don't have to take minutes and have resolutions. You don't have to, treat the corporation like it were some big, huge business when it isn't. LLCs, you sort of form it and forget it. So long as you keep all of the assets of the LLC separate from your personal ones, which is very key, you will get the benefit of the LLC protection and all of the tax benefits too. Now, in some state legislatures have gotten wise to how great LLCs are, so they charge a little more money for them when it comes to certain annual fees you have to pay. For example, in my state, California, there is a gross receipts tax on an LLC that has a minimum of $800 a year and a maximum, I believe, of $12,000 a year, depending on your gross revenue. Now, $12,000 is a lot, but it is, if you're making $10 million or more in gross revenue, it's probably not that big of a deal. So anyway,
it's a rounding error expense and maybe a bit of a nuisance, but not.
Yes, exactly. So there you have it. Corporation versus LLC. Probably for Canadian people coming over, it's going to be C Corp versus LLC. And for the great tax reasons and formality reasons, LLC is often a really good choice.
All right. I won't get into the complexity of visas and what happens if they have an E2 visa and they come across and all that. We can deal with that on another webcast. So the second question. Yes, no. So bottom line is Adam is going to be a great resource in determining what type of a business structure you should have. So the second question should be kind of near and dear to me a little bit is, how will I raise that capital required to operate my business? I'm interested to hear what your thoughts are on this one.
All right, great question. So, capital raising is principle on the minds of most new entrepreneurs and people who form new companies. And it's not like there's rocket science around it, but we're going to talk about it anyway. One way to raise capital is to do it all yourself. Just do it on your credit cards and out of your savings and do the best you can. That's usually called bootstrapping. After bootstrapping, there's always friends and family. They're always nice to go to. But both of those things, bootstrapping and friends and family, have pretty major limitations to them. If you're going to go out to the marketplace to try to find money, it's important to remember that you want to try to stay away from the registration requirements of the United States federal government. That's like the SEC, the Securities and Exchange Commission. Registering your stock sales or your equity sales with the SEC is a huge expense fraught with complications and risk. It's so much, I don't even practice in that area. It's too huge. You have to hire a big law firm and a big accounting firm to help you with that. And if you're a huge business, have at it. Otherwise, you want to stay away from that. How do you do that? You seek capital only from people known as accredited investors. Accredited investors are basically wealthy people who the law feels can take care of themselves. What does it mean to be wealthy under the accredited investor standards? Well, they have to have one or the other of these two things. Either $1 million in net worth that does not include their primary residence, or they have to make, if they're a single person, $200,000 a year, or if they're married, $300,000 a year over the course of the last 2 years, plus a reasonable expectation they'll do it again this year. So,
I have a question about that. So I have a question about that second point on the net liquid net or the income. Is that a state regulated or is that a federally regulated? So does it matter if you're in Utah or Missouri or here in California? Does it matter? that criteria of the
That's a
income.
federal rule. Doesn't matter if it's Utah,
It's a
California, or
federal. I
Missouri.
just wanted to double check on
Right.
that.
And in California, that's not very much money. You're not all that rich if that's what you make. Maybe in Missouri, it's a lot different, or Utah. But even so, that's the standard. So you try to look, you really want to only seek capital from those people. If you do that, then you will be free from having to register your securities and be under the yoke, cost and administrative burden yoke of the SEC, which is really important. Okay, then once you find these people, what kind of investments are available? Well, there are really four kinds that are more common these days. You can have debt financing, equity financing, convertible note financing, or something called SAFE, SAFE, which stands for Simple Agreement for Future Equity. These are the things that are happening now. So equity and debt and convertible notes are kind of old-fashioned. SAFEs are brand new. Anyway, equity financing is when you sell your shares of your LLC or corporation to this accredited investor in return for a capital contribution of money. Age-old way of investing. People who will do that might be someone called an angel investor who is interested in coming in early on. They're not angels because they're nice to you. They're angels because they come in before you've proven your concept. Generally, they extract large prices for their equity investments in terms of taking a valuation which is more in their favor and many other kinds of concessions. But anyway, if you need the money, there they are. Private equity firms are also available now and awash with capital trying to find places to put that. Generally, brand new companies are not so easy to get private equity money, but if you're an existing business and you're opening up an arm in the United States, you might find some private equity out there interested. And there are plenty of people in the US called investment bankers who are dialed into the private equity world and can put people together. An investment banker is a broker for capital raising. So they can put people together to do that. You need to be careful about how much equity you give over. This is the lifeblood of your future investment. If you're really just a mom and pop and you're trying to build something for your future and your family's future, giving away 10, 15, 20, 45, 50% of your company could have humongous consequences to you if you are very successful in the future. So you got to be careful to get the right valuation and the right kind of investor. That's equity. Debt is you take out a loan from somebody. It could be a bank, although banks need collateral, and sometimes there isn't much collateral to give when you're a new business. But if you're an existing business, you might have plenty of collateral to give. The best thing about debt financing is they don't want any part of your business. They just want to get their paid back with interest, and they don't want to foreclose on all your collateral. They will if you don't pay them back, but they don't want to. And if you end up paying them back, now you have used their money to grow, and you have no partner, and that's great. So debt financing is very viable for many kinds of businesses, and sometimes preferable. But of course, you have to pay them back. With investors in equity, you don't have to pay them back. Their capital contribution is not a loan and doesn't get back to them until there's a capital event, like selling.
They just have ownership in the business now. You can use the capital, and they get a piece of the rewards at the end of the day.
That's
one of
correct.
the things I've noticed in my experience, because we come across folks who are looking for capital, and it's pretty clear that the bootstrapping and family and friends is like the first layer. If you're not having your own capital and you're looking for money elsewhere, you basically have to go through that process and work up to the next level. Because I find that if you're looking for some seed money to get an operation off the ground, you're not going to have much luck looking for angel investors. That's my experience anyway. You need to come in with the initial bootstrap family and friends group to help get the operation running, and then you can go out and start raising capital. That's been what I've seen. You may have seen otherwise, but that's
you're not wrong, Wayne. On the other hand, I have also seen angel investors who like to invest in very early stage companies. I mean, there are organizations of angel investors. There's one in our local community called South Coast Angels that hold fairs where you can come and pitch your business and find angels there. So it certainly can happen, but it's easier if you have an ongoing business with a track record and profits and revenue and all that.
People like to see that sort of thing.
They certainly do. I guess really quickly, I'll mention the convertible note, which is a hybrid debt and equity where you take a loan from an investor, and that loan will eventually, under certain circumstances, change into equity. Many investors really like convertible notes because it reduces their risk. And then there are these SAFEs, simple agreement for future equity, which are like warrants or stock options in a way. They pay money now for the ability to buy stock later upon the happening of a certain event, like a capital raise at a lower price. That's what a SAFE is.
And you're saying that's becoming more prevalent these days?
Yeah, SAFEs I think they're really new. I mean, I don't think they even existed 3 years ago. So they're really new and they're gaining a lot of popularity. So I work with them a lot these days.
All right. Well, listen, you've given us lots of different options for raising capital. Is really helpful. We have one more question. And again, one of the things we always talk about, Adam, is that, you work at the intersection of business and employment. And so we're going to kind of lean over onto the second part of that. And we're going to ask you this question. What are the pros and cons of having employees versus independent contractors?
That is a great question.
In California is a real thing. It's a real
right. So I can speak to this federally and also in California. But first we should define our terms. An employee is someone who you control and direct their work, and because you're allowed to control and direct their work, there's all kinds of rules about all these laws that employees get to be benefited from. And most workers in this world, certainly in this country, are employees. Independent contractors are supposed to be independent businesses, be them sole proprietorships or corporations or whatever, who provide a service to you and to others because they're a business. And you pay them money in return for the service. And you have a contract, and they're not employees. You don't direct and control them. They're an independent business, and there's something outside of what you do. That's the idea. If any of you out there ever hired my law firm would be an independent contractor. We provide legal services to you and many other clients. You pay us money for our services, and we're not your employees, and you don't control us. You don't know how to do law. You want us to help you with that. So that's what independent contractors versus employees are. Now, many small businesses love to hire independent contractors to do work for them. Why? Because they're less expensive and have less legal liability attached to them. Mm-hmm. I think that I've heard between 20 and 30% less expensive to hire an independent contractor for the same work an employee would do, because you save on a lot of the taxes and the employee benefits.
You don't have the benefits program that you're responsible for.
That's right, where that comes from. And then of course all the labor laws and employment laws that are here in the United States and in my state, California, don't apply to independent contractors because they're not your employees. So, if entrepreneurs and businesses had their druthers, they would hire only independent contractors. But unfortunately, that's not possible because the laws, both federally and in my state, California, are quite restrictive about who can be an independent contractor. Now, the laws don't get involved right away. It's really between two people. If an employer, you as the company and a worker want to be independent contractor relationships, there is no big eye in the sky looking down and you're saying, no, don't do that. That's not the way it works. You go ahead and do it, and then you suffer the consequences at a later time when a government entity is maybe auditing your tax returns, or maybe the worker applies for some benefit like unemployment insurance or workers' compensation, and lo and behold, there isn't any for them because they were not classified as employees, or maybe they just sue you later on saying, I should have been an employee, you were wrong to make me an independent contractor. All those things happen later. And then if you did it wrong, there are tremendous, terrible consequences that can befall you for doing it wrong.
And the consequences are bared by the employer, not the employee.
That's correct, Wayne. Even if the employee begs you to make them an independent contractor and signs, oh, I want to be one, it's all me, it's not him, none of that's relevant. That does not come into play in any court or any tax situation. What the employee wants or says are irrelevant. So it's the employer's decision, and if the employer makes the wrong decision, that is making someone a contractor when they should be an employee, the consequences are terrible. I'm talking about many penalties that are going to be owed, punitive kind of penalties, not to mention very high interest rates and all the attorney's fees you have to pay for your own attorneys and the attorney of the other side.
And this could also be applicable, just to be clear here, even if both the employer and employee are on the same side of the page here, and they're both wanting to have this relationship, the risk of being sought out by regulators is still there. It isn't only if an employee makes a complaint.
That is correct. Absolutely right. If there's never a complaint by the employee, one or both of you can still be audited. Once you're audited, then they've got you. And many employees or workers love you to death until you fire them, or until they need money. And at that time, they don't love you to death anymore. Yeah. So, you want to make sure that you properly classify workers as employees when they should be. Now, under federal law, it's easier to classify an independent contractor as such. There are 20 factors that are considered, and the 20 factors are weighed so that one factor alone is not enough. One has more weight than the other, and I'm certainly not going to go through all 20 factors, but I will tell you that if you add all the 20 factors up and you boil them down to their essence, they're really just two. And that is, how much do you control them? The more you control them, the more they're going to be your employee. And second is, how independent of a business are they really? Do they really have a business like I do in my law firm, or are they just an individual person who works for you, and says that they're a business, but they're really not. They don't have websites, they don't have clients, they don't have all that stuff. So that's how it all boils down in federal law. Under California law, I don't know about all the other states, but it's harder. So it's not a balancing test here. It's a 3-factor test, the ABC test it's called. All 3 have to be there to make someone an independent contractor. 1 is you don't control them. 2 is that 3 is that they're an independent business, and 4, I won't stick that up without. Maybe I should go over here. 1, 2, 3. And the third one is, the second test is that they can't work in the usual course of your business. And that's a real killer because, for most businesses hiring these workers, they are working in the usual course of their business. Imagine me hiring me to help you in your business. I wouldn't be in the usual course of your business. You're not a law firm. Wayne is a financial advisor. He's not going to be working in your usual course of your business. But if you're an electrician, if you're if you're hiring people to do sales for you, sales is in the usual course of your business. If you're hiring people to run your office, if you're hiring people to be your in your management,
your administration, all of that,
all the things that are usual course. So to try to wrap this up, the question was, what are the pros and cons of having employees versus independent contractors? If you can have independent contractors, the pros are they're cheaper. The cons are you don't control them, and they have their own businesses, so you might not get everything out of them that you want. The pros and cons of employees are, the pros are it's if you make someone an employee, there's no liability for that, right? The cons are, and pro is you get to control them as much as you want. Cons are they'll be more expensive and they're subject to all those employment laws.
There's a lot of risk involved, though, in these days of having self-employed employees. That's what we have to. I guess we can always thank the Dynamex case in California for bringing that out to the into the open. We've really only scratched the surface on this topic today. I realize that just a couple of additional questions, Adam, before we wrap up here. I know we're kind of running short on time, but that's fine. The first question is what would you say? Maybe just give me one example of one of the most frequent mistakes that you see entrepreneurs make, or what they should be avoiding when they're establishing a business here in the United States. Maybe look at this from the lens of the Canadian coming down here. If you can just maybe name one, error like that you maybe see frequently that they want to try to stay away from.
All right. Well, you asked me for one thing, but I made a little list, so I have it here. It won't take me long. I'm just gonna go through it. The big mistakes are the wrong legal entity or not the right legal entity. The independent contractor employee thing, that's also a huge mistake. Not having correct insurance. This is a big deal. In America, you have to have workers' comp insurance for every worker. If you don't have that, it's a crime. Not only are you uninsured if something terrible happens, plus there's lots of other insurances that you need here because we're so much more litigious than everywhere else. So liability insurance and the right kind, cyber, employment law, general liability, all kinds are very important to have, and not having them is a big mistake. I would say giving away too much equity to investors. And on the flip side of that, having partners where you don't need partners. I think that's a big mistake that a lot of entrepreneurs make. They don't believe in themselves enough to do it alone, where really the biggest upside in business is when you do it alone. So I'd say that's my list.
I would agree with all of those ones. I've experienced a couple of them myself, so I can vouch for you on that. Okay, so some time for a little bit of non-binding advice here. What kind of advice would you give to a Canadian entrepreneur who's looking to expand into the U.S.? Just, we've tried to avoid some mistakes. If you give maybe some encouraging advice, what would you suggest?
Well, Wayne, you and I have met in a networking organization with a lot of wonderful professionals. And I think the best advice that I can give is to make sure you have the right professionals working for you and with you when you come to America to open up your business. Or if you're an American listening to this, if you open up your business at all here in the States. Who are they? You need the right business lawyer. You need the right employment lawyer. You need a great accountant who doesn't just do tax returns, but who understands business accounting and the difference between corporations and LLCs and that kind of thing. You need a great financial advisor like Wayne Baxter for all the money you're going to be making and where you're going to invest all of that. You need a great insurance broker, but not for avoiding the insurance problems I've just mentioned. You need good real estate advisors if you're going to have a place that you're going to rent or buy for your business. You can really tank yourself with the wrong kind of real estate advisor. I could go on, but I have to say that the right people around you, the right professionals, that's the most important thing.
All right. Well, listen, as I knew would be the case, you've been an awesome guest. We've included your contact information, of course, here on the screen. But for someone who's watching in or listening in today and they'd really like to reach out to you, what is the best way for them to contact you? Is by phone, email? What would you recommend?
Thanks. I think usually the best way is by email, which is atreiger@szrlaw.com. I'm very good responding to emails quickly, but sometimes emails get lost in the junk file or something, especially if they come from another country like Canada. Sometimes the junk files just take them right at the junk. Anyway, so you can always call me. My number at the office is 805-446-1496.
Adam, I want to thank you again. Awesome guest. Look forward to having you back again.
Thank you so much, Wayne.
Our guest today has been Adam Treiger. He's a partner with Southern California-based law firm Stowell, Zeilenga, Ruth, VAUGHN Treiger, LLP. Great guest. Can't wait to have him back again. I look forward to bringing you the 3 Questions webcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our YouTube channel. And to receive notification of when our latest webcasts have been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you and see you soon.